And I know that every community I've met has been a living system. And the law, which as a lawyer, I acknowledge that I represent, the law can be a process of violent paving over that living community. Um, it can also be a useful tool to enable that community to get to places it wants to or needs to go. And often it's a mix of both. My hope here today, and a recurrent question I invite each of us to ask as we embark, or maybe we're already embarking on the journey of thinking about incorporating becoming a charity, is how do these categories help facilitate our communities and meet our needs, continue as living systems? And how do these categories actually in some ways artificially constrain, misdirect and confine the growth of our communities? We'll be talking about various legal considerations, but ultimately your vision for your community will escape any legal categorization. Will be larger and deeper than that. So I invite you to think pragmatically about the use these categories can have, but not feel you have to be confined by them. So with that reflection or big picture in mind, and thank you everyone for continuing to introduce yourselves. I will give you a bit more. Someone's asked, is it going to be recorded? Yes, it will be recorded. And yes, these slides will be available. I'll introduce a bit more about who we are at CLEO, Community Legal Education Ontario. We're a legal aid clinic, part of Ontario's legal aid system. In contrast to other legal aid clinics, we do not provide one-on-one legal advice or representation. So I can't personally look over your documents. I can't advise you specifically on how to move forward, but we provide general, plain language and practical legal information and education. We do this on a range of topics: employment, housing, human rights, seniors and powers of attorney, you name it. We likely have legal information about it. That might be useful to you, your volunteers, your staff, if you have any, and the people you serve, the people in your community. So I encourage you to check out our website, stepstojustice.ca. And if you find that you're serving communities that are coming to you regularly with legal questions and you don't know how to find them the resources you need, CLEO actually provides training and capacity building for frontline workers to equip them to be better able to provide that legal information. So if that's something of interest to you, I'm going to provide my contact information at the end of today's session, and I can also put you in touch with other people from CLEO. Now, today's session is made possible by the generous support of the Laidlaw Foundation, the Law Foundation of Ontario, and the partnership of the Ontario Nonprofit Network. All right. Some housekeeping. There will be a period for questions after each section we discuss, after incorporating, after charitable application, and so on. With that being said, I encourage you to keep the questions flowing throughout the chat. I'll periodically check the chat. If there are any urgent questions, I'll address them when they're relevant. Why wait? And as a lawyer, I'm very fond of disclaimers. I have not one, but 4 disclaimers for you today. So firstly, as you've already heard, everything today is general legal information. It's not tailored legal advice. And that's not because I don't want to help, I in fact do, but I can't effectively help because I don't have your governing documents in front of me. I don't know your vision. I don't know the history or culture of your group and so on, all of which are vital to know how to provide proper advice. So feel free to ask questions, but just know that I can only provide sort of general parameters and information in response. Today is meant as an introduction. It's not intended to be comprehensive. I'll show you at the end of today's session a link to our website where you can learn a lot more about everything, most of the things we'll be discussing today. Thirdly, today is about law. It is not about everything else that goes into starting and running an organization. Your community, the psychology, the history, your vision, the politics, etc. All those things are very much outside of any expertise I could claim to have as a lawyer. So I'm happy to field whatever questions you would like answers to, but just know that I'm limited in what I can help you with, and that you have many of the answers you need. And then finally, today is about law. It's not about your funder's expectations. So there are various legal minimums to consider as part of the process of incorporation and charitable status. And in many cases, funders do have different or greater expectations than just those legal minimums. So my job today is to highlight the options that are available to you, but you know your funding model, your revenue model best, and what the expectations that come with that are. Okay, so with that, we're going to begin with choosing a structure. We're going to go over the pros and cons of whether to even incorporate or not. We're going to talk about if you're going to incorporate as a business or incorporate as a nonprofit. What's the difference and what are the pros and cons? Then, if you decide to incorporate, we'll look at the pros and cons in taking the further step of applying for charitable status, which, as I'll explain, is an additional status on top of becoming incorporated. There's how we incorporate, and then what is our tax status? What is our status in the eyes of the Canada Revenue Agency? We'll then look at membership models, which is probably the most fundamental question. It's at least one of the most fundamental questions from a corporate law point of view or a governance point of view, which is basically who holds power in your organization from a legal standpoint, and how do you make decisions. So we'll look at different options for how you might structure yourselves in the eyes of corporate law, and the pros and cons for that. And then finally, we'll look at shared platforms models where you basically work with an existing organization that it has charitable status, and you are from a legal standpoint part of that broader organization or have some agreement with that organization. We'll get into more detail on all this in just a moment. Okay, so to begin, when two people come together and they decide to do pretty much anything together other than make a profit, right? So let's say two neighbors get together and they want to start a garden, right? And the other neighbors come and say, oh, garden, this is a great idea. Let's make a community garden, okay? So as soon as those people get together and they pursue this common goal on a regular basis, they form what's called an unincorporated association. Now, unincorporated associations, they don't have any legislation that specifically applies to them. So the rules for unincorporated associations come from two places. Number one, they come from the collected decisions of common law courts going back hundreds of years that set out certain basic principles. Like, for example, decisions should be made by consensus by default, right? A surprising principle that we actually find in the common law. The common law means the accumulation of all these court decisions. So there's no piece of legislation that governs all the rules. It comes from all these court decisions and from the governing rules that the organization creates for itself. You may call this a constitution. You may call this your community contract. You may have any name for it, but it's the set of rules and principles that you decide will govern your work together. Okay. So unincorporated associations can basically set up whatever rules they want for themselves. But unlike corporations, which is what you become when you become incorporated, there's a corporation is created. Unincorporated associations do not have any independent legal existence. The people who legally exist are the people, right? There's no separate entity that we call the association or the organization. So the association is very flexible in its rules, but it isn't a legally independent entity, which means that, for example, if anyone gets sued, it's going to be the individuals, not the association. If anybody enters a contract, it's not going to be the association that's liable for the contract, it's going to be the individuals, and so on and so forth. Okay. Whereas with a corporation, if an organization, submits paperwork to the government, provincial or federal governments, they can create an entity called a corporation, and that corporation has a legal existence. That corporation can enter contracts. It's liable, and so on. So that is the basic difference between an unincorporated association and a corporation. Now, what are some of the pros? What are some of the cons of being an unincorporated association versus a corporation? Well, first and probably foremost for many, a corporation protects the individuals involved from liability. Of course, individuals can still be liable if they personally do things that are negligent, or if they intentionally hurt somebody or something like that. Individuals can still be liable, but the individuals involved in the group are not collectively liable for everything the group does. A corporation is legally responsible for its own actions. With an unincorporated association, that's not true. The individuals are responsible for what the group does. So the first benefit of a corporation is that it protects the individuals from liability. The second benefit of a corporation is that it has a permanent legal existence. So as I mentioned, it's very easy for people to come together to form an unincorporated association. As soon as they come together and they start pursuing a goal in common on a regular basis, you've created an unincorporated association. Congratulations. But easy come, easy go. As soon as people start drifting away, the unincorporated association ceases to exist. Not so for corporations. Even if all the people who started the organization, drift away, start doing other stuff, the corporation keeps existing. Other people can get involved. There are various ways to, for example, take control of corporations or transfer control of corporations, and that corporation keeps on going and can keep doing the work of pursuing its mission. So for an organization with a long-term vision, there may be something attractive about this idea that we're coming together to create something that could outlive us. Number 3, clear legal framework. So I mentioned that with an unincorporated association, the rules come from basically your own governing documents, whatever you decide for yourselves, and sort of the past case law. With corporations, legislation like Ontario's Not-for-Profit Corporations Act, the Canada Not-for-Profit Corporations Act, sets out a very detailed framework of how governance is expected to happen. And if an organization doesn't create its own rules, doesn't create its own governing documents, these pieces of legislation set out all kinds of rules that apply by default. So if you say nothing, these are the rules that apply. So this can be helpful in that it saves you the trouble of having to reinvent the wheel. You can just sort of say, okay, we'll just follow, these are the default rules. The legislation's already kind of thought through all these questions for us. We don't need to think through these questions for ourselves. As we're going to see in a moment, that's a bit of a double-edged sword. But it has the clarity of a pre-established framework. And then finally, and probably most practically for organizations that are just starting out, many funders, not all, but many, choose to make their funding exclusively available to incorporated entities. Now, this is a choice, and it has to do with a funder's risk tolerance and so on. There are a mix of good and bad reasons for why funders choose to limit their support to corporations often. But the reality is many funders do limit their support to corporations. So to be eligible for that funding, if that's the kind of funding sources a group plans on seeking, then having a corporate status is often a key to those doors, a way in to access that funding. Those are the pros of becoming incorporated. So what are the cons? Well, first of all, it's more paperwork. A person has to go to the government, whether provincial or federal, and file corporate applications, and then on an annual basis has to tell the federal provincial government, there's been change on our board, or we've changed our address, or what have you. So there's more paperwork involved. There's definitely more administration. There's a cost involved in becoming incorporated. It's a few $100s if you seek legal advice, depending on where you seek legal advice. It could easily be a few $1,000s. And then there's also more rigidities. So I mentioned the legislation sets out a clear framework, but the drawback of that is that framework can be rigid. It cannot reflect the cultural norms or decision-making processes of your group. It could crowd out governance structures that you want to achieve that, for example, you may find more just, more egalitarian, more appropriate. So that's something to be mindful of. I do want to emphasize that many times people think certain things are set rules in the legislation, and actually it's not the case. There's more flexibility than people realize. So there is lots of room for creativity and flexibility. One doesn't have to do things the way everybody else does that just because they do it that way. But with that being said, there are some things which are legally mandated in the legislation. And you can learn more about that on our website. So those are some of the pros and cons of incorporation. Basically, to summarize, it comes down to the benefit of being unincorporated is more flexibility and less administrative work. The downside is less eligibility for funding, less permanence, less protection from liability. The flip side, if you want to incorporate, the pro is more permanence, more of a framework, more protection, and more eligibility for funding. The downside is more rigidity and more work. Okay, so you've decided we want to become incorporated. What kind of corporations are there? So I'm going to talk about two here, but they're actually three, and it's important not to remember the third. But in most cases, people are interested to hear about business corporations and nonprofit corporations. But the third kind of corporations are cooperative corporations. And in fact, cooperative corporations could either be for-profit cooperative corporations or nonprofit cooperative corporations. So a lot of what I say applying to both business and nonprofits also applies to co-ops, depending on what kind of co-op you want to be. I'll talk about a bit about co-ops at the end of the slide. Okay, so what's the difference between a business and a nonprofit? Well, a business can pursue any profit. Any purpose. Now, primarily, and usually it pursues profit, but there's nothing to stop a business from also pursuing other purposes alongside profit. Businesses have shareholders. So these are people who actually own the corporation. You could have one shareholder, you could have many shareholders. The legal responsibilities of the business are a bit different. It's generally speaking more oriented towards profit. So if they start pursuing other aims, if a shareholder is displeased with that, they can, take the director to court, for example. Businesses are eligible for some funding that nonprofits aren't, and they aren't eligible for some funding that nonprofits are. So it really depends what type of funding an organization is planning on pursuing, which status makes sense. Let's contrast this with nonprofit corporations. So nonprofits do not have owners. Nobody owns the nonprofit. Instead, nonprofits have what are called members. We're going to talk more about this later. Members are people to whom the nonprofit, from a legal perspective, ultimately answers. So every year, there's expected to be at least one meeting with the members where the members get to vote on who's on the board. You might call it your executive, so who basically oversees or controls the nonprofit, and they can remove those people. They can vote on important things like, are we going to have an auditor, or what kind of financial review are we going to have? If there are any changes to the governing documents, the members' approval is ultimately required. Major decisions like mergers, changes to purposes, changes to names, and so on, requires member approval. So who the members are is super important. They're like what shareholders are to a for-profit, they are to a nonprofit, except they don't own the nonprofit. They just control and oversee it. Nonprofits, in contrast to businesses, are not taxable. Now, one needs to be careful here. Nonprofit refers to a corporate status. You can be a nonprofit corporation, which means you don't have any shareholders generally. Nonprofit is also a tax status. A nonprofit corporation, if it behaves like a business, can end up being taxed. So this isn't like a massive loophole to get around taxes. If it earns revenue and does business like a business, and then takes that money and gives it to its members as if they were shareholders, that's the key step. Nonprofits can engage in all kinds of business activities. They can engage in all kinds of revenue earning activities, but they can't do so in a way where the purpose of that is to basically pay out shareholders, like the equivalent to shareholders. So this is often the big advantage of being a nonprofit. They are tax exempt, but as I mentioned, there were some restrictions in their ability to earn revenue. I can take more questions about that if it comes up. And then there's lots of funding which nonprofits are eligible for, which businesses aren't eligible for. So I've talked about businesses, I've talked about nonprofits and some of the trade-offs between them. What about co-ops? So co-ops could be either businesses or nonprofits. The difference with a co-op is that there's a much more specific governance structure. And basically what it comes down to is one member, one vote. Regardless of how much money, for example, you contributed to the organization, it's one member, one vote. There are also certain limitations about who can be on the board, they need to be a member, and so on. Co-ops are all about mutual aid, members serving members, kind of economic activity based on mutual support, as opposed to just endless profit accumulation. So that may be appropriate. You can also recreate some elements of a cooperative structure in a nonprofit or in a business, but if you want the accountability of committing to cooperative principles, and you can learn more about that from the Ontario Cooperative Association, then incorporating under a cooperative statute can be a great way to legally build in the accountability of these principles into your organization. Okay, so let's say you decide to incorporate as a nonprofit corporation. Then there's a question of, do we want to seek charitable status or not? Now, a charity is a nonprofit. So this is where sometimes it gets confusing. Are charities and nonprofits the same thing? Are they different? If they're different, then are they completely different? Are they overlapping? So charities are a kind of nonprofit. They're a kind of nonprofit that pursues purposes that fall within 4 categories that have developed over time through the courts. The 4 categories are basically relief of poverty, advancement of education, advancement of religion, or other purposes beneficial to the community. And that other catch-all category, there's a list of purposes that have developed over time, such as protection of the environment, promotion of animal welfare, promotion of health, protection of craftsmanship. There's a long list we could go down of purposes that fall under this 4th category. So when I talked about the idea of the law can be a road that takes you somewhere, but it can also pave over, the organic life of your community. Charity law is a great example of this. Charity law may reflect the purposes that your community is genuinely trying to pursue, or it may be very artificial, very outdated, very, sort of colonial, reflecting case law, outdated ideas of what the public benefit is, and you may find it very constraining. The key thing is that if an organization becomes a registered charity, it needs to ensure that its purposes and its activities remain exclusively charitable. Not we do some charitable stuff and we do some non-charitable stuff. If an organization is going to be a charity, it has to be exclusively charitable. That's where the risk of constraining yourself comes in. But what are the benefits of being a registered charity? So some of the biggest benefits include a registered charity can issue tax receipts. So this gives donors a tax credit. And they can receive money from other registered charities with basically no strings attached. One charity can give to another charity and they just give them the money and that's it. Now, the rules have changed in this area, and hopefully by the fall, I'll be back with Laidlaw to do another session on those changing rules. It used to be that charities couldn't give to non-charities unless they maintained what's called direction and control over those funds. And direction and control could be quite controlling and prescriptive, as the words kind of suggest, which was, paternalistic, unfair, didn't recognize the expertise on the ground or the ownership of the community, and so on and so forth. The problems were myriad. So recently, some changes were made to the Income Tax Act that allowed charities to make what are called qualified disbursements, also referred to as grants, to non-charities, as long as certain safeguards are in place to ensure that the non-charities only use the resources, the funds, for charitable purposes. So there's still a level of accountability in there. There's still a level of safeguards and frameworks and checks and balances. So there's some additional paperwork and so on. It's not no strings attached, but now it is possible for charities to give to non-charities. Whether foundations take up the call to actually do that remains to be seen. Some certainly have and are taking full advantage of this flexibility. The rules haven't quite been settled yet by the Canada Revenue Agency, so stay tuned for more on this. But the bottom line is organizations that choose to not become registered charities may be eligible, if they do charitable activities as part of their programming, may be eligible to receive some funds from charities with some additional strings attached. But many funders may choose not to make their funding available to these non-charities. By becoming a charity, the advantage is the organization clearly is eligible for funding from all kinds of other charities. An additional advantage to being a registered charity is there's more flexibility around revenue earning. Charities can basically earn revenue indefinitely, as long as that revenue earning comes from either the charitable programs themselves. So think, the University of Toronto Faculty of Law is technically a charity, right? The tuition that the students pay is quite high. So you can earn a great deal of revenue and still be a charity by even charging for the charitable programming, such as education or arts performances and so on. The second way charities can earn revenue is through investments, as long as they're passive investments. So this is, many foundations have investment portfolios and so on, and they earn revenues from those investments. And thirdly, through what are called related businesses. And that's a whole session unto itself, but the Canada Revenue Agency, the CRA, has rules about what it considers to be a business that would be related in some way to the charitable activities. Think, selling t-shirts with your logo on it, or if you develop certain products, such as crafts, as part of a workshop you're doing, those crafts can then be sold. And the revenue can be used for the charity as a kind of offshoot of the charitable program, and so on and so forth. So there's a list of related businesses charities can engage in that nonprofits would face limits in how much revenue they could earn, but the charity wouldn't. The registered charities are subject to far more paperwork, both in the application process and in the kind of annual filings. And they're subject to much more scrutiny and oversight by the Canada Revenue Agency than are nonprofits that aren't charities.
It requires you to bring in other.
I note they're also subject to the oversight of the public guardian and trustee. So an organization that commits to being a registered charity needs to ensure that they are prepared to remain within the bounds of what a charity is allowed to do. And that can often be artificially constraining. I note that there are a number of questions in the chat, so I'm just going to pause a moment to look at them. For clarity, co-op organizations are social enterprises. Can co-ops be charities? Great question. So the idea of a social enterprise is not a legal term. in Ontario. So it can refer to a bunch of things. Nonprofits can be social enterprises, businesses with a social mission could be social enterprises, but the Ontario Cooperative Association does refer to co-ops as the original social enterprises. Definitely co-ops have a kind of a traditional social enterprise orientation. But the truth is you can do social enterprise through any of these structures, potentially. There are always trade-offs. Can co-ops be charities? In some limited cases, the answer is yes. For example, daycare co-ops. But in many cases, the answer is no, because co-ops are generally oriented towards mutual benefit, whereas charities are supposed to be oriented towards public benefit. So not just the members are benefiting. Are the terms nonprofit and not-for-profit interchangeable? Is there a legal difference? Thank you for that question. That's a very common question. I use the term nonprofit because I consider it kind of generic. I'm conflating between a bunch of different terms. So there are not-for-profit corporations. So often not-for-profit will refer to the corporate status of an organization. And then there are nonprofit organizations, which is the term that the Income Tax Act uses to refer to the tax status of a nonprofit. With that being said, usually when people are using not-for-profit and nonprofit, they're not specifically referring to the Income Tax Act versus the corporate statutes. They're using it in a more colloquial or interchangeable way. Are there any laws governing social enterprise or social purpose orgs? So there are some laws federally in BC and Nova Scotia. And in BC and Nova Scotia, they have specific hybrid corporate organizations that incorporate elements of business and incorporate elements of social mission. These organizations cannot be charities because they have that profit purpose component. Similarly, business corporations at the federal level can take on a status which essentially is supposed to be a social enterprise status, which just means that they invest 51% or more of their revenues, of their surpluses, back into their mission. So at BC and Nova Scotia, the additional rules have to do with what you add into your governing documents saying you're going to pursue another social mission in addition to profit, and the reporting requirements are slightly different for them. But by and large, they're businesses with some slight legal differences. Does spending requirement increase proportionally with revenue due to the disbursement requirements? Yes, so all charities, nonprofits do not have a disbursement requirement. All charities, almost all charities have a disbursement requirement unless you have a very low annual revenue. The disbursement requirement is 3.5% of your assets, and it goes up to 5% on assets over $1 million. And that was changed recently as well. Most nonprofits and most charities that are operating in the community have absolutely no problem meeting this requirement. This is a very low threshold for most organizations. Where it matters is where you have funders, for example, whose assets are subject to certain trust rules, where they're only allowed to access a certain amount of the funds in any given year, and then it can lead to administrative complexities. Do nonprofits have revenue earning / profit limits? So they don't have revenue earning limits per se, but they do have surplus limits. Basically, CRA expects nonprofits to operate on a cost recovery basis, so like a break-even basis. But the break-even basis includes a reasonable reserve. What's considered a reasonable reserve, and a reserve means funds you put away for a rainy day, basically. What's considered a reasonable reserve depends on your reasonable expected expenses. If you have a robust reserve policy, where you say, we plan in 5 years to buy our own building or to expand our services, and or we need to redevelop where we're leasing a space now, we really need to redevelop the equipment, or we want to do X now. If you dream big in your reserve policy, that's fine. You're entitled to do that as a nonprofit in pursuit of your purpose. And then the CRA sees that reserve policy and they say, okay, they are collecting surpluses in order to fill this reserve. And we know they have a clear purpose in mind. They're not just accumulating for the sake of accumulating, right? If you have a clear reserve policy, then the CRA has said that in those cases, you could even have a reserve up to 12 months of your annual revenue, which could be quite significant, and that could still be quite reasonable. But beyond what you could justify by a reasonable reserve, nonprofits aren't allowed to just pursue. Otherwise, they may start getting taxed. Has there been any changes where nonprofits can give receipts to supporters? No, and that's unlikely to ever come because it's like a categorical difference between nonprofits and charities. The whole purpose of charities, or more broadly, the qualified donee status, which includes organizations like registered journalism and organizations, the whole point of the Income Tax Act having these specialized categories is because they control really what's a very significant power to be able to issue and redirect tax funds, basically, to issue tax receipts. So it would be a massive change to the Income Tax Act to extend that to nonprofits. I wouldn't expect that anytime soon. Okay, thank you for your great questions, and keep them coming. I'm going to go on a bit more, and then I'll return to the questions. Okay, so the final question in this section of, how are we going to actually structure our organization is this really fundamental question. So this is assuming you're a nonprofit. If you're a for-profit, the equivalent question would be, who are my shareholders going to be, and what's my share structure going to be? But if you're a nonprofit, the fundamental question from a legal standpoint, again, there are many other factors to consider in a community. I'm just speaking from a legal standpoint. The fundamental question from a legal standpoint is, who are my members? Because these are the people who, from a legal perspective, ultimately control the organization. So I'm going to go over 6 different common structures. And I want to highlight that you can mix and match, mash and meld and create hybrids and come up with all kinds of creative structures. But these are just 6 different common types. I'm going to go over what they mean and the pros and cons associated with them. So the first structure is open membership. Open membership is basically where a nonprofit says anyone who supports our mission can become a member. The pro of this is the openness, right? For a broad-based or a grassroots movement, it can be very attractive, very consistent with a person's organizing principles to be so completely open. This can be a way to draw more support. Members can pay a membership fee. This could be a source of revenue, for example. This could be a way to source potential future leaders in your movement, if you think of yourself as a movement, potential future volunteers, board members, etc. Those are the pros. The cons are, well, once you open the door to anybody, you have to be prepared for anybody who might walk in. Right? They may have a different idea from you about what the direction of the organization should be. They may have, a different agenda. They may have, different purposes in joining and so on. And as I mentioned, members control the organization. So when somebody comes in as a member and has voting rights, for example, at the members meeting, they can get together with their friends who can also join the organization, and they could potentially take the organization down a different road. Now, that may be part and parcel of community and internal democracy and governance and so on, or it may be very bitter and toxic and personal struggle, right? These things vary. But when it comes to having open membership, one has to be prepared for the possibility that such a thing can happen. Even if a group of members doesn't want to necessarily take control of the organization, having more people You need to contact them. You need to include them. They have rights in the governance. They have right to speak and so on. Meetings may take longer. They can put things on the agenda. They have all kinds of rights to access documents and so on. So being prepared, if individuals are going to be included, or organizations, because actually also organizations can be members of a nonprofit. If individuals and organizations are going to be included in an organization, that organization needs to be prepared to honor their rights and so on in the decision-making process. Model number 2, semi-open membership. Semi-open membership is where a nonprofit says anyone can join, provided that the people meet XYZ conditions. The conditions can be anything from paying a membership fee, to signing a code of conduct, to signing a statement of principles, to being from a certain area, to being from a certain community, to, you name it. You can be very creative and flexible in how you define the conditions for membership in your nonprofit. This has many of the same pros as open membership in terms of, being able to source wide group of members. That infuses energy into the organization. There's more communal accountability and so on and so forth. And it guards against some of the cons of open membership in that you can set some safeguards and some parameters on who can come in the door, make sure everybody's aligned, and so on and so forth. And these mechanisms can also be used as a way to remove people if they become inappropriate as part of the group. The additional cons for semi-open membership is you need to be prepared to enforce the conditions and do so consistently. You have to have certain administrative processes in place to make sure people have met the conditions, even if it's as simple as they have to fill out a form and submit it. Okay, so what does the form look like? Who do they submit it to? Where do you keep the forms, etc. Thinking through these kinds of logistics is important. Model number 3, self-perpetuating board. This is an increasingly common structure in the nonprofit sector. It's where the directors, you may refer to them as the executive of the nonprofit, the board of directors are the only members of the organization. So there's nobody else who elects the directors. The directors essentially elect themselves, and they choose their own successors, and so on and so forth. So the pro of this model is that it is easier to control, right? There's less opportunity for external shenanigans, let's call them. It's easier to administrate. So when you have a meeting, for example, you need to send the notice of the meeting out to far fewer people. Easier to keep a record of who's a member and know exactly who the rights are. Those are some of the pros. Some of the cons are that it can lead to a closed culture. This can lead to less diversity. It can lead to a kind of cliquishness. People can, even if they're not actively being excluded, they can feel excluded. Members of the public may not realize that they're not actually members of the organization, so they don't have legal rights. And I get complaints from people on a regular basis, members of the public, who ask me these types of questions. They think they're a member, and then they find out they're not actually a member, and then they're often quite scandalized by this. So thinking about what's the perception in our community if we're going to have this closed structure, what might be the perception of the press if something ever went to the press, etc. Those are all things to think about when considering a self-perpetuating board. Model number 4, single member. So if you are an individual founder and you're starting out, maybe you're a social entrepreneur, etc., and really it's your livelihood that you're considering pursuing through a nonprofit. You may really be concerned that you're going to put all this work into this organization and then someone's going to take it from you. So one really basic way to guard against that is to be the only member in your nonprofit. When somebody is the only member in the nonprofit, it's very difficult for anybody else to have any rights to, for example, remove them or change control of the board, and so on and so forth. So that individual has considerable control of the organization. That's generally speaking the pro. Also, it's much easier to invite people to meetings when you're the only one. You can just sit there and be a meeting. The con is all the same cons of the self-perpetuating board. you may be perceived as closed. People may find it a bit funny that there's only one person who controls everything. Thinking about your own sustainability. If you're having trouble finding other people who want to be members of your organization, what does that say about the practical viability of the organization? If it all rests on you, is that sustainable for you personally? What happens if you leave, right? What happens if you can't do it anymore? What happens if you need to take a vacation, etc.? So these are all considerations when it comes to the single member structure. Then we start getting into more complex or hybrid structures. So number 5, hybrid membership. Hybrid membership is where you have multiple, what are called classes, multiple classes of members, and the different classes have different rights. So you can have one class of member that has voting rights and one class of member that has non-voting rights. So for example, let's say you're a sports league, right, for children. So you want the children to be members because you want them to be included in part of the organization, but you don't necessarily want the children to be voting on major asset sales. So you make the children non-voting members. And who are the voting members? Let's say maybe your board are voting members. So this combines some of the benefits of open membership in that it gives you a way to include members of your community, and this can increase participation and increase inclusivity and source potential future leaders and new ideas and so on and so forth. But it also has some of the benefits of a closed membership, like a self-perpetuating board, where the only voting members are the board, so they have a consistent idea of maybe what the vision of the organization is, etc. So you're getting a bit of both. The downsides of a hybrid membership is that they're a bit more complex to maintain. You need to understand who's what kind of member, that they have different rights. It can be easy, for example, if all the members are invited to the meeting and you're saying to some people you can vote and some people not, that can be an awkward conversation to have. And because corporations are permanent, it's important not to just think about yourself and your own understanding of your organization, but 3 years down the road, 5 years down the road, 10 years down the road, who's going to be involved and what's their understanding of the organization going to be. These things can get lost in translation. So hybrid memberships, I find it's easier for people to lose sight of the nuances, and then they're not, administering the organization's governance properly, basically according to the legal requirements. Another example of hybrid membership or a multi-class membership is what's called representative members. Representative members, membership structures, are where there's a group of people, let's say everybody in Ontario, right? And then everyone in Ontario has the ability to elect certain people, and those people are then the members of the organization. So if you've got a province-wide organization, so you might divide the province into regions or nations or territories or whatever is relevant for your community, and then those subgroups they aren't themselves the members, because that would be, from an administrative perspective, a nightmare to have so many people. You have to keep a list of all the members. They're not the members, so you don't need to worry about them being the members, but they do have rights to elect people. And those people are then a smaller group of people who have the legitimacy of being elected by a wider community. So you get more of that inclusivity without necessarily having to have such a wide membership. So you get some of the benefits of a smaller membership, less room for co-optation, and combined with some of the benefits of having wide open membership. These can be quite complicated to actually administer in practice. You need to think about, how are we going to do elections? How are we going to communicate with the people who aren't our members? What are their rights exactly going to be, etc. Okay, so I see there are a number more questions. I'm going to pause here to read these questions and also invite more questions. And you can put your questions in the chat, or you can raise your hand, whatever makes sense for you. Okay, so how many members does a charity need? So a charity and a nonprofit have the same requirements in this respect. Both only require a minimum of 1 member. With that being said, there are different requirements when it comes to the board. So members of the organization are like the shareholders, and then there's the board, which answers to the members. The board is like the executive. Those are 2 different things. The board for a charity needs to have at least 3 people sitting on the board. For a nonprofit that is not a charity and doesn't receive public funds in excess of 10,000, and by public funds I mean either donations from members of the public or funds from governments or agencies of government. At the federal level, they can have even 1 director. So if you incorporated federally, you could have even a board of just 1, as long as you didn't receive public funds above 10,000. At the provincial level, organizations are required to have at least 3 directors, whether or not they're a charity. Thanks for naming that model. The board I sit on has the structure, but I didn't know the term. Yes, there's lots of terminology. And one thing I'll say about terminology is that a lot of the terminology is colloquial. And so, figure out the language that makes sense for you. In some cases, there is legally specific language. And so it can be helpful, for example, in one's governing documents to have a definition section to explain how the terms that you choose to use relate to the terminology in the legislation. But be mindful that sometimes terms are defined in legislation and sometimes you can give them whatever meaning you want. Can federally registered nonprofits have self-perpetuating boards? Would this affect applications for charity status? Federally and provincially registered nonprofits can have self-perpetuating boards. Would it affect application for charitable status? No, not necessarily. There's nothing in the charity application form that asks specifically, like for a list of your members, for example. One thing I will note, however, so while your members and board can be the same people, when it comes to being a charity, your staff, it's very complicated and highly restrictive for your staff and your board to be the same people. So very often, let's say you're a social entrepreneur, you're starting out, this is a way for you to make a living, and you're wondering, can I be a charity? And the answer is yes, you could. But if you want to be both an employee or earn a salary or get paid as a contractor and also sit on the board, you're going to run into trouble. You need to follow a guide, and if you're in Ontario, called paying directors and connected persons. And I should say I'm in Ontario. Some of you may not be in Ontario. I'm only speaking about Ontario law and federal law. There may be other provincial statutes that apply to you if you're outside of Ontario. So if you're a charity and you want somebody who's being paid by the charity to sit on the board, then in Ontario, you have to follow the guide paying directors and connected persons. And it's highly limited, the situations in which it's allowed. So that is something to be mindful of. Now, this is also an area where I mentioned in the disclaimers, there is a difference between what the law allows and your funder's expectations. So there are some limited circumstances in which an employee may be allowed to be a board member of a charity. There's a lot more flexibility for nonprofits from a legal standpoint to have employees as directors. But funders, many funders I've spoken to do see this as a red flag. If there are employees on the board, they want to know why that's the case, because there are potentials for conflicts of interest. And the law does require organizations to limit and mitigate and get rid of, if possible, these conflicts of interest. But funders can be particularly sensitive to these structures. One thing I'll note is that if an individual is just starting out, and so they want to be an employee, they want to be on the board, they want to be a member. Firstly, think about how sustainable is that for them personally, the time and work involved. Secondly, if they're choosing to do this because they're having trouble finding other people to serve on the board, that may be a red flag, right? That there isn't enough support, for example, for this organization for it to necessarily be viable or achieve the level of formality or work it takes to incorporate. Thirdly, if there is interest, but an individual is uncomfortable giving up the control to other people, then this may be a sign of, of issues that will happen down the road for the organization, what's known as founder syndrome, where there's too much control in one particular person, and they can't give up that control, and so that affects the long-term sustainability of the organization if they ever need to transition out of the organization. So all of these things are worth considering if an individual is thinking about, I need to be an employee, I need to be a member, I need to be on the board. But for a nonprofit that isn't a charity, it is possible. Can nonprofits registered in Ontario in 2022 have self-perpetuating boards and have charitable status? Yes, it is possible to have self-perpetuating board and have charitable status. These membership models apply to both nonprofits and charities, correct? Yes, that is correct. As far as membership structures and governance structures in general are concerned, with the exception of what I just said about employees being on the board, nonprofits and charities are broadly speaking very similar. Where charities are different is in the specific purposes they pursue and therefore the activities that they can pursue. But from a governance perspective, nonprofits and charities can be very similar. Are there any other questions about anything we've discussed to this point? You can put it in the chat or raise your hand. Okay, not seeing any, so we're going to continue on to the next section. Oh, I forgot about shared platforms. So before we continue on the next section, I'll talk about shared platforms. Okay, but before that, I'll answer this question. Is it possible to function as a nonprofit and a charity at the same time? So it's important to keep in mind that there are sort of two sets of laws. There's the corporate law, and then there's the tax law. And it can be confusing because the term nonprofit is used both in corporate law and in tax law. In tax law, nonprofit and charities are different things. You can't be both at the same time. You have to be one or the other. But from a corporate law perspective, one can be a nonprofit corporation, and then for tax purposes, be a registered charity as well. The point is that a registered charity is a subset of nonprofit corporations. It's also possible to be a charity without being a corporation if one creates a trust, but that's outside of the scope of today's presentation. Okay, but let's talk about if none of these structures work for you, right? You don't necessarily want to incorporate, you don't want to become a charity, or maybe you do in the future, but you're not there yet. What can you do? Well, there's such a thing as a shared platform, which I'm sure many of you will be familiar with. There are different kinds of shared platform relationships. So a project's relationship to a shared platform changes with its legal structure. But broadly speaking, a shared platform refers to an organization, usually with charitable status, that hosts or provides support to smaller organizations or smaller projects to give them the benefit of the administrative structure and sometimes the charitable status of the shared platform, without that smaller project or organization having themselves to get incorporated or to get charitable status. What exactly the shared platform relationship looks like depends on whether the smaller group is unincorporated, incorporated, or even registered charity. So if the smaller group is unincorporated, then the way a shared platform typically works is for that smaller group to be legally part of the shared platform. So although it may have its own name and it may have its own programming, and in practice, the people who run the project are still running the project, right? For legal purposes, they become part of the shared platform's management and governance and decision-making structure. The bank account is the bank account of the shared platform. The reporting requirements are the reporting requirements of the shared platforms. If the unincorporated group receives funding, the funding agreement is with the shared platform entity, because the unincorporated group doesn't actually have its own separate legal status. If it starts acting or talking like it has its own legal status, that can cause problems with the Canada Revenue Agency. So the trick, if a group is unincorporated, is to make its legal status as a part of the shared platform as much as possible. If a group is a nonprofit, but it doesn't have charity status, then typically the relationship between the shared platform and the nonprofit will be one of an agreement, a contract between the two entities that will often look like something like a direction and control agreement. Or a fee for service agreement. So the shared platform may provide certain finance or administration services and infrastructure, and then the nonprofit pays a certain percentage of the funding it receives to the shared platform, et cetera. As I mentioned, there is now a new option in addition to direction and control, which is the qualified disbursement regime. What exactly those agreements will look like going forward has yet to be determined. The policy, the final policy of the CRA hasn't been released to the public yet. The final form, if you will, is if the nonprofit, the smaller nonprofit actually has registered charity status. It's just small, so it would like to benefit from a sort of mentor organization and the infrastructure that the larger shared platform has. Well, in that case, if they're both charities, there is huge amounts of flexibility in how they can work together. So it's really up to the agreement between them. Here's a guidebook Laid Law created alongside the Ontario Nonprofit Network in 2016. Yes, the ONN Shared Platform Guidebook, I highly recommend it. And we have some more recent resources on the ONN website building on that guidebook. So I invite everyone to share that. Okay, now I'm done this section. Are there any questions before we move on to the next one? What would be the benefit of being an incorporated shared platform? So the main benefit of incorporated groups working with a shared platform is if the shared platform has additional infrastructure. So that infrastructure might be, things like an HR framework, so it's easier for them to hire, or they can provide benefits to your employees, or they can, they have a better, they have a space, like a physical office space. So you're actually, renting or using or licensing their office or event space. They might have insurance. Which especially now, Imagine Canada recently put out some statistics that charities are finding it increasingly difficult to be able to afford insurance. So if a shared platform has an existing relationship, they're a larger organization, they can achieve economies of scale, there might be some way to be included within their insurance. So these are all examples of benefits that can be achieved, even if an organization is already incorporated. Now, how many shared platforms are out there? Is there one for your particular area? Is the relationship right? Is the timing right, etc.? All that is a very case by case, and that's what the guidebook helps with. Is there a name for the fee paid by the smaller org to the larger org in a shared platform / incorporated model? Not to my knowledge. Typically, it would be referred to as a kind of administration fee or the cost of administration, something like that. Is this shared platform the model used when one group creates both a nonprofit entity and a charitable entity that are linked? No, but thank you for bringing that up. That raises a whole other area. So far we've been speaking about creating a single organization and what the status of that single organization is. The truth is, it's quite possible, and many, especially larger organizations, have multiple entities that do different things. For example, you've got hospitals that do the work of, healthcare, and hospital foundations that do the work of funding the hospital and of fundraising. This approach is used in order to segment the different functions, in order to distribute the risk and liability and so on. If an organization, for example, is broadly charitable, but it also wants to engage in partisan political activities. Well, charities can engage in advocacy. They can engage in unlimited advocacy. They just can't engage in partisan advocacy. So if an organization wants to engage in partisan advocacy, then there needs to be a separate organization created that's dedicated to that that partisan work, for example. Similarly, an organization like a charity may have a business idea that doesn't fall into the category of, passive investment related business or charitable programming. So what do they often do? They create a separate for-profit entity, a for-profit business corporation, and they run the business out of the business corporation. So then it's two separate corporations that are linked. So that's possible. There are advantages to that. It's more complex and more administrative work. How would the partner orgs in a shared platform apply for funding? Would the smaller present itself as independent, or would the shared platform apply as a partnership? So it depends what the nature of the shared platform relationship is. If an organization is unincorporated, then it's definitely the shared platform that is applying for the funding. It's their name, which is sort of the official name on the application. If they're going to receive the funding, there'll be their names on the checks and so on and so forth. The project will be the name of the program or so on and so forth, the thing that is being funded. In the case where you have two organizations, both of which are incorporated, you may have a situation where the charity receives the funding, the shared platform receives the funding, and works with in partnership, maybe has a contracting agreement with the non-charity. So in that case, the charity applied for the funding, and then there was a separate agreement. Or you could have the nonprofit apply for the funding, receive the funding, and then has a separate agreement with the charity. So it really depends. In the case where both are registered charities, total flexibility, right? It could be partnership, they're both listed, one of them's listed. It also depends on the funder. How do nonprofits set up foundations with charitable status? Is that a shared platform model? No, so a shared platform model is where there is a broader organization that already exists that supports a smaller organization and provides various kinds of supports to it, may channel funding, etc. An organization that has a corresponding foundation, and basically the way this is done, there are a few different ways, but the way this is done is that the nonprofit creates a separate nonprofit, is then, for example, the sole member. Remember, I talked about a membership structure where you only have one member. Well, that one member could be a corporation. So the nonprofit's the sole member of the other nonprofit. And then that nonprofit has a mission to raise money, to give money to other organizations, right? And it becomes a foundation. That's not really a shared platform framework, although of course the foundation could go on to become its own shared platform. But that's more what's referred to as a parent subsidiary or a family of corporations. Yeah. Okay, lots of great questions. So in the interest of time, we're going to move on. Oh, one more question, and it looks like a juicy one. All right. If a charitable organization wishes to engage in social enterprise activities, can it be done as a charitable organization, or does a separate organization have to be formed? Would the second organization be a nonprofit in that case? So again, social enterprise is not a legally defined and specific term. It basically, colloquially, it means solving some kind of social problem using a business model. There are plenty of business models which charities can do. There are some which they can't. So it depends on what the social enterprise is specifically, whether it makes sense or needs to be a charity, a nonprofit, a business, or a cooperative corporation. But all of these things are possible. But as I mentioned, charities have a wide latitude in the ways and amount of revenue they can pursue. If an organization becomes incorporated and enters into a shared platform with a larger org, does the smaller org still need a nonprofit membership model, or do they use the larger org's model? So if an organization is incorporated, it needs a membership model. Even if the only members are the board, or even if there's only one member, basically all corporations, with a few exceptions, basically all corporations need members. There's no requirement for the membership model of the smaller organization to be similar to or track the shared platform membership model. All right, keep them coming. But now we're going to shift gears and we are going to focus on the actual process of incorporation. So the first thing, if you look in the, and this is focused on Ontario, by the way, the first thing you'll see if you look in the Ontario Incorporators Handbook is a requirement for a name. So nonprofits have to have a corporate name and may also have a trade name. So what are these two things? So an organization can go by more than one name. The corporate name is its official legal name. That's the thing that's put on the governing documents. When you sign contracts, that should be the name of the organization listed and so on. That's the corporate name. The trade name is the name you go by in the community. So for example, you know, the YMCA might be referred to as the Y, for example. So the idea of the Y, now I'm not sure if that's actually their legal name or their trade name, but if it was not their official name, but it's just what everyone called it, that would be a trade name. Trade names need to be registered separately from the official name under the Business Names Act. But there is an opportunity if you know all the names you're interested in when you first become incorporated, there's an opportunity when you incorporate to list the other names as well. You need to get a report that says nobody else has your name already. No other corporation has your name. Just a disclaimer, getting a nuanced report and incorporating with a name is not the same thing as trademark protection. What incorporating with a name does is it means no other corporation can incorporate with that name, but it doesn't mean nobody else can use that name. Trademark protection is a whole other area of law, but you would file with the Canadian Intellectual Property Office the name and any kind of visual elements associated with the name if you wanted your brand to be protected. Your nonprofits, incorporators, and directors. So you need a starting group of people to become incorporated. And so this relates to the question I was asked about the minimum number of people on the board. You must have at least one incorporator, and this is your nonprofit's first member. They have the power to elect directors and pass bylaws at the first meeting and so on. Your first board, provincially, I mentioned, there needs to be at least 3 directors. You can have more, you can set a range if you'd like in your founding documents, but there needs to be at least 3. If you incorporate federally, it's possible under some circumstances to have fewer than 3. Directors need to be over 18. They can't be bankrupt or to have been found legally incompetent by a court, but they do not have to be Canadian residents. So that's something to keep in mind. Directors need to consent in writing to be directors. Your nonprofit's address. In Ontario, nonprofits have to have a physical address. A PO box is not enough. This can be a personal address, for example, of a founding director. Keep in mind that this address is accessible through the Ontario Business Registry if you incorporate provincially, so people can actually look it up. You can also work with, here's an example where working with a shared platform might be useful. You can work with a larger organization and they might lend their address to you and be the place where you go to get mail and so on and so forth. So why is this address important? Well, in Ontario, by default, it's the place where you're expected to keep important records. It's where board and members meetings will take place by default, unless you provide something else in your governing documents. And it's a place where the government will send important documents. Okay, this is before your membership structure, this is probably the most important decision for your organization overall. The purposes of your organization. And again, this is where I remind you, you may have a vision, right, that is broad and holistic and is complicated and is rich in many ways. And then the task and sometimes the violence of the law is that it wants you to write that down in a piece of paper in a nice, intelligible way that is understandable to the government. Now, for nonprofits that are not charities, you can actually be very flexible in how you write your purposes and what they say and so on. If you are a charity, however, the CRA can be quite prescriptive in how it wants to see your purposes. So this is something to be aware of if you're planning to apply for charitable status. Reading the documents on the Canada Revenue Agency website about how to actually write your purposes can be very valuable to save you time from having to change it down the road. So a nonprofit can have any legal purposes other than making a profit. So you could have a UFO society, you can have a bowling club, you can have everything in between. You can have commercial purposes. So if you're interested in social enterprise, for example, you can have various kinds of business purposes. But if you do, you have to include a line in your founding documents, what are called your articles of incorporation, that say that any surplus will not be given to the members, but be reinvested in your purposes. Now, you may have the question, can people be paid if it's a nonprofit? The answer is yes, but they can be paid for the work that they do, which is different from how a shareholder gets money. They get money in the form of dividends just because they're owners, right? That's different from paying somebody in exchange for the work that they do for the nonprofit. Now, as I mentioned, if you want to be a charity, then your purposes have to be exclusively charitable. So we already covered that list earlier. Once an organization becomes incorporated, there needs to be the first meeting of the directors. And at this meeting, they need to approve a set of bylaws. This is basically your constitution. If you are looking for resources or examples to draft bylaws, you can go to our website, which I'll provide at the end of this webinar. This applies to provincial nonprofits. If you want to incorporate federally, Corporations Canada has a bylaw builder that can give you a good starting point. The first meeting of the directors, they also need to call the first meeting of the members. So whoever you define as your members, they have to meet to approve whatever the directors do, because again, the members have the final say. This first meeting, the directors may make banking or financial arrangements, working with credit unions or banks, for example. They may appoint officers. So we've mentioned members. We've mentioned directors, the board who oversees the organization. What about things like president, secretary, treasurer, etc.? So that's entirely up to you what positions you have. Provincially, there's a requirement to have a chair, but every other position is entirely up to you. You don't have to use these names. You can use other names. You can give them whatever job description you want to give them. And there's lots of flexibility. And yes, employees can be officers. Members must, and even for charities, there's much more flexibility. Members must then meet to do any or all of the following: vote to approve the bylaws that the first board approved, elect a new board. So that first board, they only serve until they can have this first meeting, then the members meet, and then a new board comes. It could be the same people, but there needs to be this kind of passing of the baton. And appointing an auditor or person to do financial review. By default, all nonprofits incorporated in Ontario have to get an audit each and every year, unless they pass what's called an extraordinary resolution at a members meeting waiving the audit. Okay, so even if you're a small organization, and if you're a small organization, you can waive the audit and then you don't have to get any external financial review. You don't have to pay for the accountant, etc. You don't have to, but you do have to take the step of passing an extraordinary resolution. There's a lot of confusion in this area, so that's why I emphasize it. This is one of those areas where the law says one thing, that you can pass an extraordinary resolution and waive the audit, and your funders may say a different thing. They may expect some level of financial review that is different from the minimum that the law requires. That's a conversation for you to have with your current or prospective funders. If you are provincially incorporated and you do not pass bylaws within 60 days of incorporating, the default bylaws will automatically apply to you. You can Google ONCA default bylaws and you'll see what rules are contained in those bylaws. You may be happy with those rules, or you may find they're inappropriate, and so you need to have bylaws ready to go. So thinking about the order of how you do things, you can be incorporated without having written your bylaws yet. But then you have a 60-day window in which to write and pass your bylaws. You may choose, and many organizations do, to make sure everything is ready before you submit any forms to the government. So everything is done at once, and then you can very quickly meet after that, have your first meeting, pass your bylaws, have your first members meeting, approve the bylaws, elect the board, and carry on with your business. What order you choose to do things in is up to you. Okay, let's look at the questions before we move on to our final section. Is it mandatory to have physical record keeping? No, it's not. From a corporate law perspective, you can keep all of your records digitally. If you're operating in a specifically regulated field, like healthcare or social services, that kind of thing, maybe, I don't know. I don't know the specific regulations that apply to all sectors. Are you able to please share a link/reference about the other purposes beneficial to the community? Can the first meeting be virtual? Okay, so other purposes beneficial to the community. Yes, absolutely. At the end of this section of the presentation, there's the last slide is where to learn more. So you're going to get a copy of this presentation after this session. If you go to where to learn more, you're going to see a number of links. One of them deals with charitable purposes, and it will, give you more information about where to learn more. Can the first meeting be virtual? The answer is basically yes, it can be. Can extraordinary resolutions be passed by members to waive an audit even if we get public donations? So you're right to point out that the thresholds of what your annual revenue is and that where you're allowed to waive an audit does change if you receive public donations or if you're a charity. But organizations up to $100,000 in annual revenue can waive the audit regardless of where they get their funding. If an organization has annual revenue up to 500,000, so between 100,000 and 500,000, if you get public donations above $10,000 worth, you can waive the audit, but you have to at least get what's called a review engagement, which is like an audit, but it's faster, cheaper, it's less expensive. Okay, so let's move on to the next section, which is what's actually involved in applying for charitable status. So here's a basic checklist of what you can expect to include in a charity application. So firstly, you're incorporating documents, your articles and bylaws. So I mentioned earlier that the charity application doesn't specifically ask about your membership structure, but the agents reviewing will see your articles and bylaws, so they will know what your membership structure is. Again, there's nothing which prohibits a charity from having a self-perpetuating board. So you include your articles and bylaws. What this means is that if you're planning on incorporating, you need to have already incorporated before you apply for charitable status. You need to include details about your activities, and you really want to provide the most detail possible in supporting documents to really show, what your activities are, and with the idea that what you need to be able to show them is that everything you're doing is charitable. So if your activities are not charitable in some respect, you need to be able to explain why, going forward, we're not going to do that, or this is why it's actually charitable, or this is how we're going to make it charitable going forward, right? The CRA does its own research. So if there is publicly available information on your organization out there on a website, in a newsletter, on social media, they're quite capable of finding it. So not giving it to them in the application with the hope that they're not going to see it because it's really not so charitable, that strategy poses the risk of them finding it, seeing that you concealed it from them, and then being more suspicious of you for that. An alternative approach is to get out ahead and address the issue, address how it's going to be handled going forward, and so on. With that being said, I can't provide legal advice specific to each situation. So this, if you are thinking about retaining a lawyer in the charitable application process, this may be part of the strategy discussion you have with them. You're going to be expected to provide detail on any income earning activities you do, your different methods, if you're planning on engaging in social enterprise, what the social enterprise is, etc., percentage of resources you dedicate to each. You'll be expected to provide a budget, financial statements, if you have any from past years, if you're just starting out, projected budgets and financial statements and so on. So you do need to think about what your financial picture is going to look like. And this is a good exercise anyway for financial planning. And then finally, any partnership agreements. So again, if you're a shared platform or you're planning on joining a shared platform, CRA wants to hear. What they're concerned about is charities working with non-charities and draining the resources, the charitable resources that received all the tax benefits to entities that are not planning to do anything charitable and just want to take advantage of the tax benefits. So they want to know if you're planning on working with anybody, firstly, are they charitable or not? And if they're not charitable, what are the safeguards that are going to be in place to make sure that the purpose of your working together is exclusively charitable? So here's a breakdown of what you can actually expect in the process. So firstly, and you know what, I want to say two things first before we get into the details. Firstly, the average process takes about 9 to 12 months. I've heard it take much shorter if you're very simple. For example, if you were just creating a foundation with very straightforward purposes, I've heard it, if you're working with a lawyer that knows, the fastest way to do everything and so on, it can take as little as 3 months, okay? That's a very optimistic case. Average time is 9 to 12 months. The second thing I want to note is that 80% of applications in the past few years have been accepted. So it's not impossible. The more complex the organization is, the more value there may be working with a lawyer to both speed up the process and to increase the likelihood of success. But even if an organization can't afford a lawyer, isn't working with a lawyer, etc., it's still possible. There's an overall 80% success rate. And by being thorough and knowing what CRA expects ahead of time, you can head off a lot of the reasons why people get rejected. Okay, so the first step is submit the application. And the first thing CRA is going to do is check, did you submit everything we asked for? You'd be surprised how many people don't. If you didn't, CRA is going to reject you immediately, okay? Reject it for incompleteness. Don't take it personally, right? All you need to do is make sure you have a complete application and submit again. If it's complete, then there are 3 ways the CRA may respond. Number 1, they may accept you. Yay, you're a charity now. Number 2, they may reject you. Number 3, they may say we need more info, or we have certain concerns. Can you address these concerns? In most cases, it's not an immediate acceptance, unless you're a very simple, straightforward organization and you've worked with a lawyer who really knows their stuff. It's unlikely to get immediate acceptance. By the same token, unless there is a really obvious red flag that it's clear what you're doing is not charitable, or you have some kind of disqualifying, private benefit or something like that, most applications aren't getting immediately rejected, right? Most organizations are falling into this middle category of we need more information or we have concerns. So if you get that letter, and it's going to be a long letter because the way they write these letters is in a copy and paste kind of way. So firstly, take a deep breath, right? Just because it's long doesn't mean it's bad. You'll have 60 days to respond to this letter. And, this isn't something where you want to procrastinate. You may need to have a bunch of back and forth within your community to really discuss about the questions they're asking, and do we want to, they may make suggestions and so on. Do we want to take it in that direction and so on, right? So taking the time to meet so you're not rushed at the end and you're not making hasty decisions that is going to, take your organization or community on a path you didn't intend just to please the CRA, right? That takes time and conversation. So 60 days is your framework in which to respond. If you fail to respond within the 60 days, CRA will consider the application to be abandoned. So you're going to have to start from the beginning, right? If you do respond, they will either respond with an acceptance or a rejection. If they accept you, yay, you're a registered charity, congratulations. If they reject you, that's not necessarily the end of the story. You can actually appeal the decision of the CRA, and you have 90 days to do so. At that point, you may want to think about seeking legal advice, because appeals can be, the CRA appeals division wants to hear things in a certain way. If it's already been rejected, chances are there may be some kind of tricky legal question here, so there might be some value on getting legal advice. But you appeal to the appeals division. Maybe the appeals division will overturn the initial decision of the CRA, in which case you're accepted, yay, you're a charity, or they may reject you. Even if the appeals division rejects you, that's not necessarily the end of the story. You can appeal to the Federal Court of Appeals, or you can give up at that point. Maybe go back to the drawing board. Maybe charitable status isn't for you. That's your decision. Okay, so that's a breakdown of the process. Here are 10 common reasons for rejection. And this comes from a law firm. There are a number of law firms in this area that put out some great, very informative material. I encourage you to check it out and attend some of their webinars. I don't include any particular law firm because I'm recommending them for you or vetting them. It just happens that this law firm has put out this helpful list of, I think, 80 common reasons that charities get rejected. So it's worth reading through the whole list. But here are the 10 most common. So firstly, the purposes aren't charitable. When it comes to charitable application, the most fundamental thing to confirm is, are our purposes exclusively charitable? So learning about what the charitable categories are, how can we fit in what we want to do in those purposes? Secondly, the purposes are broad and or vague. So it may be that some element of the purposes are charitable, but the way they're written leaves some words that are ambiguous. When it comes to drafting purposes, I mentioned there are words that are legislatively defined and there are words that we just kind of use colloquially. When it comes to drafting purposes, it's important to use words that have more precise meanings, clearer meanings, whether it's defined within the governing documents or whether it is defined legally in some sense. For example, past court cases. Purposes don't reflect activities. It's not enough just to write down on paper that you're going to be exclusively charitable. Your purposes need to be actually reflected in what your activities are. There needs to be a connection between them. You need to be able to draw a line how these activities are going to further these purposes. And that's also part of thinking through your theory of change and so on. But sometimes when organizations start out and they're kind of experimenting, oh, we want to do a bit of this, a bit of this, a bit of this, and what's driving the desire to do these different activities have more to do with the interests of the people involved or the passions of the people involved than a theory about what is actually going to advance the overriding purpose. That's totally okay and legitimate for a nonprofit to do that. For a charity to do that, it becomes trickier to convince the CRA you're exclusively charitable. If there's a lack of information, that might be a reason the CRA, rejects the organization. So here's an invitation to really think through what you're planning to do to develop the materials and so on. Unstated collateral purpose. This is a fancy term which means that the CRA suspects that you have a purpose you're not telling them about. And maybe you aren't, writing it down on paper. Maybe you aren't saying it out loud. But really, all these things you're saying you're doing is for some other purpose. Usually that's the case where an organization has one vision and they're trying to crowbar themselves in to charity law, but they aren't really giving up on their overarching vision. These tensions, can sometimes mean that the CRA is kind of knows you're trying to do both, and it can lead to an organization painting itself into a corner. Lacking public benefit or delivering improper private benefit. It's important to recognize that there are many things that you may pursue that you believe and have every reason to believe are beneficial to the public. And you may even be right. But that is different from what the Canada Revenue Agency understands as a public benefit for the purposes of charity law. Charity law has this tradition of court cases where judges have decided this is beneficial, that isn't beneficial, or this is beneficial but not beneficial in a way that's charitable. The classic case of this is the case of sports, where courts have said, yep, sports may be very beneficial to the community, but it's not charitable. There are other examples of things like this. So don't take it personally if the CRA says we don't see the public benefit. It doesn't mean what you're working on isn't worthy or isn't worthwhile or beneficial. It just means from a charity law technical perspective, it doesn't fit into the boxes they've developed over the years. If fundraising is the main purpose of the organization that isn't charitable, what's charitable is what the funds get applied to, but it's important in an organization not list fundraising as its main purpose. If it's promoting culture or multiculturalism or mutual understanding, that is not charitable. There is a distinction here for organizations promoting the benefit of Indigenous communities, which may involve the promotion of Indigenous cultures, because there's specific case law on that topic. But for example, an organization that's simply promoting Croatian culture, for example, or Polish culture, I'm not choosing these for any specific reason. It's really any culture. But if you're a specific cultural association, that in and of itself is not charitable. Now, if you're promoting education about, Croatian history and culture, or Polish culture or history, or whatever, then that's different. That's advancement of education. But the promotion of the culture itself, the case law has found, is not charitable on its own. Similarly, there may be direction and control issues if a charity is planning to work with a non-charity, but isn't planning on, exercising direction and control, or more recently, using a qualified disbursement framework. Okay, so working with a lawyer. The first thing I want to emphasize is that working with a lawyer is never all or nothing. At the end of the day, complying with charity law, unless you can afford to have a lawyer there at every single meeting all the time, right? That's not something a lawyer can do for you. That's something only you can do for yourself. So you really understanding your governing documents, really understanding what makes you charitable, what fits within a charitable purpose, is going to be crucial for setting yourself up in the long term for success and legal compliance. There's lots that you can do for yourself, and then that will limit what you need the lawyer to do for you. The more education, the more you understand, the more targeted your questions will be for the lawyer. That can save time and money and so on. So it's never all or nothing. A second caveat I'm going to add is that it depends on the lawyer. Not all lawyers practice in charity law. So making sure that the lawyer you're working with has a background working with charities, has a background working with charities in your particular community, all of that contextual knowledge can be really important to make sure that they are not, giving advice that's inappropriate for your vision. With that being said, what are the pros and cons? So the pros of working with a lawyer is that it can be faster. There can be less back and forth with the CRA because the lawyer knows how to speak with the CRA in a way that they they can hear and they can understand. You may otherwise be denied for avoidable reasons. So for example, maybe your organization is fundamentally charitable, but you just don't know how to articulate it in the correct legal terms. So that's something a lawyer can help with. Especially if you're imagining something that's could be charitable, but it's sort of on the cusp. It's like innovative. It's pushing the bounds a bit about what charitable is. Well, the more innovative something is, the more conservative you need to be in your arguments, because you need to prove to the CRA what we're doing. It looks really novel, but actually it's similar to this case and this case and this case. And the better knowledge a lawyer has of the pre-existing cases, the more ammo they're going to have, in the fight to make the case that you are in fact charitable. Some cons can be expensive. Estimates I've heard range from 6,000 to 12,000 in normal cases. In more complex cases, I've heard, upwards of 18,000, 20,000, etc. This is something to maybe speak with your current funders, if you have any, about if they may support the funding costs of a charitable application. It can be disempowering depending on the lawyer you're working with. They may, take charge of the process. You may not feel you can, disagree with them or disagree with their advice. You may feel insecure in doing so. You need to know at the end of the day, the lawyer's job is to advise you. It's ultimately your decision, and it's your vision at the end of the day, which is at stake, and your community members. The lawyer goes on their way, your community remains. That's something to keep in mind. And lawyers have different dynamics in this respect. Not all lawyers know charity law, as I mentioned. On our website, there is a directory of lawyers. We don't vet or recommend any particular lawyer. We just confirm that some part of their practice is working with nonprofits and charities. Okay, where to learn more? So I'm going to just give you a brief rundown of the types of guides you can read. You don't need to read all of these things, but if you're a keener, if you really want to immerse yourselves, there's lots of reading you can do, and it's available for free on the CRA website. So I'll go through this and then I'll take questions. How to draft purposes for charitable registration. This is a really fundamental guide which will be useful to anybody who's planning on doing the writing of their purposes themselves and is thinking about applying for charitable status. So this is much more of a how-to. Now, what I'll note is that CRA policies they articulate how CRA wants to see things. The law is actually broader than that. You could have perfectly charitable purposes that do not fit into the boxes that CRA sets out. The advantage of following the boxes CRA sets out is it's going to be more recognizable to the CRA agent on the other side who you're working with. And so you're going to get less questions and back and forth and so on. The disadvantage is maybe these boxes really don't reflect how you talk about yourselves and how you view your purposes and so on. In which case, be prepared for more back and forth and more of a discussion about how you've still met the requirements for charitable purposes. Secondly, and this is a really foundational guidelines for registering a charity meeting the public benefit test. This concept of public benefit is really the central concept of charity. So understanding this will really give you a sense of what is charitable. And this is a good starting point for the person who asked about what falls under the fourth category. This is a good guide to read, and you'll see it references all kinds of other guidances. Fundraising by registered charities. So this can be a useful guide to help you understand how you can raise money. What kind of revenue earning is possible is fundraising. Books and records is a good primer on what kind of records you're expected to keep and for how long and so on. Registered charities that promote racial equity is an example of a guidance that falls under the fourth purposes. Applicants assisting ethnocultural communities, again, falls under the fourth purpose. So if you're serving a specific community that shares a common identity, these guidances can be quite useful. Charitable work and ethnocultural groups, same idea. Other common guides that are helpful: promotion of health, serving youth, engaging in community economic development, which could also fall under the category of social enterprise, advancement of education, and relief of poverty are all common guides. And the one I would add to this is related business. I don't have that on this list, but if you Google related business CRA guide, you will find it. Okay, let's look at some of these questions. I'm not sure if you'll be talking about this, but what would be the considerations of provincial versus federal incorporation? I won't. Some of the considerations include they have slightly different rules of governance. The federal system is a better online system. It's a bit more customer service oriented, although Ontario's system is getting better. There are different thresholds for financial review. Federal is more onerous than provincial. There are different rules around ex officio directors. So these are people who are automatically directors because of some office they hold. If you want somebody, let's say an elder in your community, for example, to automatically be on the board, so you want this ability to have ex officio directors, then that can be done provincially. Federally, it can only be done with certain workarounds. There are a few other examples, but there are indeed differences, and they're worth considering. Regarding the percent of resources dedicated to activities, I have heard that there is a restriction of the amount of advocacy an org can do that can disqualify them from charitable status. Is this true? It is no longer true. It was true prior to 2018. There was a limit of 10% of what's called political activities. That rule was changed. The Income Tax Act was changed. Now, charities can engage in unlimited public policy dialogue and development activities, PPDDAs. As long as that advocacy is in support of a charitable purpose, charities can engage in an unlimited amount. In the past, many organizations I know of were unsuccessful gaining charitable status for many reasons, such as what you were speaking of. However, that aside, hearing you say that 80% are getting approved in general, would you say the success rate is higher now than it used to be? Yeah, I mean, it's gone through phases for sure. I think we're at a higher point now than, for example, a decade ago. In the 70s or 80s, there was a much wider acceptance, I think, of what was considered charitable. Not that I was around then, but this is what I've heard anecdotally. Can you repeat that? Organizations that are cultural are not charitable. So here's where I want to be very careful. Organizations whose purpose is to promote a culture, with the exception of promoting the welfare of Indigenous nations, right? Organizations whose purpose it is to promote a culture, that's not a charitable purpose. With that being said, organizations that are cultural in the sense that they serve a specific cultural community. So let's say you have a long-term care home that's specifically for elders in the Chinese community. That is possible because there is an advantage to having that service rendered in a culturally sensitive and specific way. Same thing with low-income housing, same thing with education, and so on. You can teach about a culture and so on. So this is why it really matters how you draft your purposes and how you frame your purposes. But it's not that cultural organizations are necessarily not charitable. It's just that the purpose has to be something other than promoting that culture. Would an organization focus on dismantling of anti-Black racism also fall under charitable work, as we have specific policies now on ABR? So great question. So one of the resources I've linked here is registering charities that promote racial equity. This guidance is 20 years out of date, and the CRA committed a while ago to updating it, and they haven't. So that's something to ask the CRA about when they're planning on releasing that. It's combating racism is a charitable purpose. What's considered combating racism for charitable purposes may be different from the way you see dismantling of anti-Black racism, right? So for example, speaking candidly, right, dismantling anti-Black racism is a fundamentally political act. These are political institutions, how we structure our society, etc. Political purposes are not charitable purposes. So if the purpose, and this may well be your purpose, to effect a structural change in society, a systemic change that is at some level political in society, that purpose is unlikely to be charitable. With that being said, many parts of dismantling anti-Black racism, such as promoting racial equality in the workplace, promoting education about racism, advancing the administration of justice by ensuring that human rights are actually upheld. All of those things can be charitable. And there are many other purposes that fit within this broader head of pursuing, of dismantling anti-Black racism that could be charitable. So again, it's all in how you structure and word your vision, and to what extent you're willing to take that broader vision and articulate it in a way that's more specifically charitable. Do all individual activities have to be considered charitable, or is it just the purpose or objects? For example, the business activities that a charity undertakes, do they just need to help meet their purposes? Also, does CRA answer questions regarding whether specific activities would be considered charitable prior to submitting a full application? Great question. So the activities need to be exclusively charitable. So all activities need to be charitable. With that being said, the Income Tax Act deems certain activities to be charitable, even though they might not be on their own. One example is a related business. So if the business activity fits within the related business guidance, then it could be charitable. Does CRA answer questions? Yes and no. So yes, there's a hotline, and I encourage you to use it. And you can be anonymous, so you don't need to worry that CRA is going to keep a record on you. You can ask them questions. But so firstly, keep in mind that if you have very complex questions, the ability of the person on the phone to answer will depend on their seniority level and experience and so on. And you may experience getting multiple answers if you call multiple times. So that's something to be mindful of. So make sure if you're addressing a complex question, you can also address these questions in writing. And that gives us the ability to triage the question to someone who's more senior and experienced, and might be able to give you a fuller answer, but they can't give legal advice, and they can't really comment on specific situations without seeing the fuller picture. So it's important not to over-rely on what you can expect from the CRA. Will these links be attached to the recording when it's sent to us? So the slides are going to be shared. Thank you. So that was already answered in the chat, and you'll be able to access the links in the slide. I unfortunately missed the first hour of my meeting ran late. I would like, could you do a review / summary of what you shared? So there will be a recording, and it's an hour worth of content. So it's probably best for all involved to just watch the recording. But what I will say is that mainly it dealt with the pros and cons of incorporating and the trade-offs in applying for charitable status versus not. Can you take donations if you are a nonprofit but not a registered charity? Absolutely. Even businesses can take donations. Anyone really can take donations. The only difference is a registered charity can issue a tax receipt. Okay, so I'm not seeing any more questions. I'll give us a couple more minutes to see if there are any more questions. So a bit more time. Absolutely, my pleasure. So then I will conclude by sharing with you my email address and the website. So I'll also put it in the chat. So if there's any question you feel like asking, but you didn't want to ask it in the group, or you think will be too involved, you can email me afterwards. I can provide legal information, not legal advice. And if you want more detail on anything we discussed, you can go to nonprofitlaw.clio.on.ca. With that, I wish everybody a very good afternoon. Thank you for your time and attention, and good luck in your process. I hope ultimately it's constructive and your community comes out better for it.